Good evening, Ma.
Good evening. How are you?
I'm fine, ma. I've reached out to the speakers, so they all confirmed their attendance just some minutes ago.
Okay, so I just want to understand what you want us to do. Is it to test our sound or to
Yes, ma. Just yes,
try to do a dry run of how we are going to do it tomorrow or what is that?
yes. Both of them, ma. Both of them. Both the sound, the order, who goes first. Although maybe Leonard Sik and Mr. Bello, then Miss Nancy. Mr. Bello is on call. Mr. Benga Bello is on call. Good evening, sir. So just basically so that we have a good grasp of how things go tomorrow. It doesn't have to take much time. But I
Okay.
think the sound is okay from my part. Good evening, sir. And
But
we
you
also
Hi, good
tried
evening.
can't control
to
network.
stream on YouTube too, because we're going to share the link also if the Zoom meeting is full. So those are things we're just trying to
Okay.
check out. Mrs. Nancy, good evening, ma.
Good evening.
Good
Good
evening.
evening.
I think the
Yeah,
only
good
person you're
evening.
waiting for is the
Good
Leonard
evening,
Sick.
everyone.
Yes.
And I spoke to him just a minute ago and he said he'll be here. So let me just drop a call.
Okay.
Okay, so he just sent a message that he will join in 3 minutes.
Okay.
Thank you.
So just to ask, and I think maybe it's because over time we've had people try to create roles. So aside moderating, will it be the moderator that would introduce the speakers, or is there someone else introducing the speakers?
It will be the moderator more.
Okay, just wanted to have the house. Very.
Yes. So we have the Leonard Sick on the call. I think we have everyone on the call. And good evening, sir. Leonard Sick, sir. Good evening, sir. Hello, sir. Can you hear me, sir?
He's
Good evening,
muted.
sir. Yeah, I'm
He's
muted.
muted.
Hi, good evening, everyone. G.O.B. G.O.B. Baba. Hello.
Oh,
Good evening, Nancy. Good evening,
Good evening,
Titi. Good
sir.
evening, everyone. Happy New Year.
Same to
Same
you.
to you, sir.
Good. Trust the year has been off to a productive start for everyone.
He's been quite busy.
Fantastic. That's where it's meant to be anyway. Yeah, that's where it's meant to be. Okay, good evening. Yes, so good we are here. Let's kick start. What are we doing?
So I guess I'm the one that's supposed to start a bit of the moderating task. But
Yes.
just to ask, Nancy, I don't know if you can confirm the pronunciation of your son name.
Nancy Nzom.
Okay. I
You
didn't
can
put
call
saying that.
you can call Nzom. Anyhow, like probably Nzom or Nzom. Anyhow, anyhow you can.
Don't worry, I will not murder your name. Don't worry.
Oh, that's fine. Thank you, ma'am.
Okay. So I guess tomorrow we'll wait for participants to get in, and then when we have the prompts that we have a good number to start. I would start, with greetings to say good afternoon.
Sorry, is it tomorrow?
Sorry?
I was going to say that.
I thought it was
it's Friday.
It's Friday.
Friday. Okay, so I will say good afternoon, everyone, and welcome to the 2025 Employment and Labor Law Year in Review, hosted by the Employment and Labor Lawyers Association of Nigeria. 2025 has been a defining year in the employment and labor law space, and is marked by significant judicial pronouncements, the continuing evolving work realities, and there are always conversations about employee protection and the employer's flexibility. And at today's session, while we'll be reviewing the 2025 today, we will, of course, have persons in the room to speak to how 2025 had been, and of course, the laudable things that happened in the year. And with me to kick the conversation forward are persons that need no introduction in the employment space. But for consistency of knowledge, for those that don't know them, I would take the liberty, of course, to introduce them, starting with Mr. Falabi Kuti, SAN. Mr. Falabi Kuti is the lead partner at Union Attorneys and the mind behind the 2025 Employment and Labor Year in Review. For some of us, we've had opportunity to read his write-up from year in, year out, where he reviews what happens in the employment space. We're happy to have you with us, sir. Good afternoon.
Good afternoon. Thank you.
Also with us is Mr. Gbenga Bello. Mr. Gbenga Bello is a renowned litigator before he then pivoted to disputes, out of the active disputes action to work with IHS Towers. He brings his invaluable perspective, not just from the litigation perspective, which he had participated in and ensured that his experience and mark was left, and has also brought that experience into the in-house employment dispute management, risk mitigation, and workplace governance. And we're happy to have you with us this afternoon, sir.
It's a pleasure to be here. Thank you very much.
Thank you so much. And of course, last but not the least is our very brilliant and beautiful Dr. Nancy Uzom. She's a distinguished employment law and law policy and the human capital market management, particularly in navigating issues around the employer-employee dynamics. We're happy to have you with us this afternoon. Good afternoon, Nancy.
Oh, thank you, ma'am. Thank you.
Okay, so having had the opportunity to allow us get to know our speakers, let's dive right in to the reason why we are here this afternoon. 2025 in review. So I guess this is where, I don't know who would prefer to start. What I have planned out is to have the learned silk start up with judicial decisions in the year 2025 and go on to Mr. Bello, then go on to Nancy, then try to, depending of course on the case Mr. Falabi Kuti decides to review or the issue of law, I then begin to look at the various issues, that arose in the course of the year. Of course, we are going to be looking at the Lakasera case. We are going to be looking at which has to do with restraint of trade and the seeming expansion of the scope beyond what the statute had provided and the judicial pronouncement. We are going to be looking at the various cases that seem to have now come to light in respect of persons in the armed forces and the decision of the NIC regarding same. And so we'll just be moving from one subtopic to the next regarding judicial pronouncement and what our thoughts are. I don't know if that works for us or if we prefer
Fantastic.
Okay.
Fantastic.
So when we
so I can give you an expo here already that Falabi and I are in disagreement on the purport and intent of the so that's going to bring a bit of fireworks, but it will be an interesting.
Yes, it will be an interesting one to look at, that one. But beyond all of that, no, fantastic. You see, at a point we're going to dovetail to particulars, and I think it is in that respect that the discussion around restricted covenants will come up. The discussion around restricted covenants will come up. Hello? This call those. Can you still let me hand? Discussion around restricted covenants will come up, and condescend on this particular Lacaseras case, and what it means for even the lower courts, because I mean that's just the singular decision of the appellate court in that area, and to that extent, it's binding on all the lower courts, except where they can distinguish and all of that. So please, we would like to, but because you wanted me to start, I think what I would like to focus on, taking a hint, a broad look at what I'd focused on, I try to focus on in the write-up that I've done, is to look more along the lines of things about the treatment of compensatory damages across board. So I like to just quickly mention that treatment of compensatory damages across board, and what would appear to be there's a need to have like a prudential guidelines for the courts. So I've just given a hint. So I don't even want anything to come up a bit. I would like to look at that, particularly in relation to when the court can follow back on the provision of its establishment statute that enables it to go beyond common law prescription to compensate a wrongfully terminated employee. Then the way and manner in which that has now been extended to, by default, I think by default, to also compensate an individual who's gone through an industrial accident. And it's of such nature that even the court found that the individual would not be able to help himself later on in life, and how the higher courts are treating it. Because I think, if you ask me, it's a bit of concern how that is being looked into. Then what would appear to be a lack of understanding among some of the judges in relation to even when and how those compensatory damages can come into place. For example, the one about the judge that I said awarded $1 million as general damages. That happened last year. $1 million as general. Do you know if it was specific? We would say that, okay, maybe she found it in the contract that, oh, the man was owed this, they didn't pay him. General damages, general is, you know what I'm saying? So, I mean, so if you ask me, that is, and I think that would basically, yes, general damages, $1 million. $1 million is well over, it's not 1 billion. Now, thank God that you mentioned the one about the military. So, as at the time I was doing the write-up, and maybe because I looked at the fact that that was what they were saying, that, well, let's interpret it that the right to leave employment should also be extended to those in the military. I later found out that indeed there is the ILO convention recognizes that the one on forced labor, recognizes that those in the armed forces, it can be an exception. The industrial court has not applied that. So by the time, so it will be good for us to start hinting it so that when it comes up, they might look at it. So even the ILO recognizes that those in the armed forces, for security and all that related matters, you cannot freely say, I want to leave. Now, as of today, last year, there were 5 judgments of the court that said they can freely leave. Those 5 judgments failed to consider that proviso in the ILO convention. And I'm really looking for an opportunity to bring it out. So this might just, thank God that you mentioned military. Yeah, because we're all jumping. 3 naval officers were allowed to go like that, 2 army officers. And I think maybe I just hints, then I'll be quiet. Then we can take it off from there. So that's the way my mind is working around that.
So, Mr. Gbenga Bello, are there any specific ones you would like to start with?
I think generally what I would like to start with is to take a
You know, sorry,
holistic.
sorry, sorry. I'm
Okay.
not sure you introduced him very well when you were going to
He
do it,
did,
so I
she
can
did. It's
understand Benga's
okay.
sentiment. You
No,
see,
it's
Benga
okay.
did a lot of those restrictive covenant cases for
Overland.
what's that
Overland.
Overland. So Benga was an active under form of the former president of the court. So he had many of those cases himself and Javio and all of that. But
Okay.
now they don't like the way they whatever. So Benga, please. I'm looking for an opportunity for us to discuss it, and I would share my view on it. I'll share my view
So
on it.
I
Thank you,
think
sir.
essentially my first job will be to just take a holistic appraisal of some of the cases that Folabi reported or reviewed in his yearly
Yes.
review, and just offer my first line of thought, on a holistic and, to generally commend the court for espousing the labor frontiers in Nigeria and for putting us on an international pedestal, and then to now drill down to areas which we think are still necessary to be critically looked at, and generally have consider options to changing. I like the fact that Folabi is dealing with the issue of monetary compensation. That is a big worry,
Hey, how come I
and I
cannot? Okay,
think
good. Yes,
and I
yes,
think that's a place
yes.
where I think I will align with Folabi. At some point, maybe after Folabi finishes his own treatise on that point, if he leaves anything, then I can add to it. But then the area of restrictive covenant, as I said, the Court of Appeal decision in Nakasera is one that still, because Falabi went to town in his review to attest to reasons why he thinks the Court of Appeal should not have gone the route they have gone. But honestly, from the first restrictive covenant treatise that I did, I had also always said that, look, if that case went to the Court of Appeal, I see a strong basis for the Court of Appeal to overturn it. So I'm not surprised. So I'm going to focus on that Court of Appeal judgment. Then at which other points? I think
You
What do you have
generally,
on
I think
regulatory?
generally those will be my opening statements. Those will be my opening statements. Then we can drill down later into the specifics as the discussion
yeah.
continues.
Okay, so what are the things you would like to discuss regarding regulatory development? Because I do understand that that's one aspect we would really like you to emphasize on during the webinar.
Regulatory in terms of regulatory development in terms of.
Okay, so let me hint at that. So Benga,
Okay.
maybe you might probably want to look at that. You see, presently, to my mind, there are two parts that I think the regulators are dropping the ball.
Okay.
And pension is number one.
Okay.
Pension is number one. The other is the application of the Employment Compensation Act
Yes.
by the NSITF. And you see the way it's coming out so years ago, I'd hinted at it in the reviews that I did, and I was invited by NSITF to give a lecture, and shortly after that, what I just saw was an upsurge in the cases by which they are trying to get employers to
pay the 1%.
Ensure,
to pay the 1%.
Yes, ensure that their employees are subscribed and they are registered and they are making the 1% contribution. Now, but it goes beyond that. And this is something that I'm happy that I wish there whatever had the time. I personally told the Director General. Now, it goes beyond that. So all the cases, if you go to the industrial court, if you go through the industrial court sites, any case that you will see NSITF, it is usually a case where NSITF has, for example, randomly gone to, let's look at, my office is very close to, there's this popular school, this British school. So NSITF will come to the British school and check how many workers do you have, give us your files, have you subscribed? Have you been paying in the last whatever? If they don't, they will now go to the industrial court. And the industrial court, you'll find originating someone that the industrial court should declare that the school is an employer within the intent of Section 3 of the Employment Compensation Act, that the school is liable to provide his record in the last 10 years for all the workers and what they've been paying, and that in the absence of that, the court should make an order that not only should they provide, they should also make penal, they should be faced with penal sanctions for not complying. So that is basically what they have been doing. Now, within the context of that act in itself, that's giving them quite wide, expansive powers, the ECA, there are many things they are not doing. The whole essence of the ECA was to look at industrial accident in the event that it comes, and let's see how we treat. And I'll give an example. The revised act envisage mental breakdown. I'm yet to see a case that's been attended to by NSITF dealing with that. All they want is
sure the board. I'm not even sure the board of that NSITF has been constituted after how many years?
Constituted. No, it's been constituted. They have a board. I know them and all of that. And so there are many things around that, and the awareness around that they are not doing. So last MBA conference, they sponsored a session where they tried to get lawyers to even know that this is what they are doing, this is what this CA is all about, ensure that your clients, they subscribe to this and all of that. But I've been saying that it goes beyond this. You need to look into the letter. People who accept when they see that you are really working in that area. I said, NAFTA didn't do anything until that lady came on board. So all we just need to do or to hear is that, somebody complained of mental breakdown and in so and was able to go to court, and they said, because they did not subscribe, NSITF should have provided money to treat her because they didn't subscribe. And you'll be shocked that there is a vast pool of insured money that can be made available for anybody who complains of accident. Accident has been given not a literal meaning. It's been given meaning that is so expansive within that law. So many things like that, that do you know that you are sitting to administer a law that aims to help disadvantage persons in certain circumstances? And we do not have record that you are very active in that area. And that is why, that is on the one hand. On the other hand, there is also what would appear to be a lack of understanding by legal practitioners every time they go to court, whether they should sue under common law negligence when an accident happens, or they should bring it under ECA. You can only do one. And ECA, you must first be sure that that framework is in place before you can come and make a claim under ECA. Otherwise, you have to. So it's, that's just one regulator that I can think.
Most people don't like to make claims under the ACA because of the minimalist kind of
but you know the challenge that they get. But you know the challenge also when you go under common law negligence.
You have to prove fault of the employer.
You know?
Absolutely.
Yes, that's absolutely. Then you see, from my reading of the court, in 100 cases dealing with industrial accident traced to alleged to have been caused by negligence of the employer, only 18 or 20 have been successful. Those 20 that have been successful, or the overwhelming figure that you find will be successful, the persons were bastardized. Do you understand that truly the judge had no reason but to just award? And I'll give an example. There was a case involving some chap who worked with a co-disco, went on the pole. They didn't tell him that they are not put off the lights or put off the power. He had that accident, his limbs, both legs, hands, they were gone. Now, when he came to make a claim under negligence in court, Justice Daley Peter said it was such a pitiable sight. That's the way he recorded the judgment. It was a pitiable sight that he couldn't look at him twice. That the only thing he remembered anytime after that case was that this man, he cannot use the bedroom without needing someone to help him. He cannot take a cup of water to his hand. He cannot move. That was so bad. And he awarded 20 million. Now, I wrote a review. I criticized that judgment that 20 million was so little. Guess what? 2 years later, two of the judges of the court forwarded to me the judgment of the, he awarded 50 million. I criticized the judgment. 2 years later, not less than 2 of the judges of the court forwarded to, because I mean they are very fond of that. If I've been hard or harsh on any of the whatever, and it's basically confirmed at the Court of Appeal, or Court of Appeal takes a different way, they let me know. So they forwarded it to me. Guess what? Court of Appeal reviewed that award down, that 50 million was too much, and reviewed it to 20 million. This man, don't forget, Court of Appeal is a final court. Court of Appeal does not evaluate facts. It is the judge who evaluates facts that you must believe everything he has said. He said, when I saw him, he recorded in his judgment. The Court of Appeal, I don't know what they use as the basis that somebody who cannot use his leg and arm would be compensated with 20 million for the rest of his adult or biological life. So, I mean, there are things around even negligence that I always have a problem that, look, by the time, but the thing that is a scale that is fixed by a law, there's a prudential guideline that must be followed. And if it is followed all through, I don't think there is a scale that says this is a limit. I've argued that.
There's a scale that is a limit. Oh. There is a form behind that says if phalanges, if you lose 5, I know that law like the back of my hand. It's a very annoying law. I
know. But let me also tell you this. You see, it would be the ingenuity of the lawyer, how you plead it. So take evasion, for example. Evasion puts a scale that, if it's a loss of bag or is a lot, whatever, you can't go beyond. This is what Montreal Convention has said. But if you go and read, what was that case, the one that is saying, Atoebi and British Airways, the Supreme Court said, yes, we will be looking at it. But in certain instances, you will look at even what the defender did to assuage the feeling. And in that circumstance, they can go beyond that and combine that. So it depends on how the case is put across. I agree with you. The scale, so just like Montreal Convention or whatever convention has fixed in aviation, in an industrial accident related matters, ECA has fixed something at the back. But what I would do, in fact, I don't like dealing with such cases. What I would do is I will combine it depending on the level of the accident. I'll combine it. The law says you cannot. Yes, I'll plead everything around that, and I'll whip up a bit and then say that this is where I sever the claim. That's just something. But as far as regulators are concerned, let's leave. I would like a situation where we even look at even how lawyers approach the court in relation to. I'm just giving an example of industrial accident or workplace injury. Let's go to pension. Do you know that pension is a big discussion before the English Employment Tribunal? So most employers don't even go near. So there are many things that we have not thumbed through. Employers deduct, they don't remit as at when due. In certain instances, PFAs, they also connive in some way, they make it difficult for you to have access when you've attained the threshold, or you've not attained the threshold, but the law says, because you don't need to attain threshold, the law allows you to draw out of it for mortgages and all of that. But I can tell you that the PFAs in Nigeria, many of them don't know, or they deliberately try to keep the money to themselves. Now, the question is, how is the court dealing with it? In fairness, the industrial court has made about 3 judgments in which they've clarified it over the years. But is that what we still find? So, if the regulatory aspect, I think if you look at pension, if you look at whatever, which other aspects of employment law?
If we are still speaking,
and yes, and I think it's the failing of either the ECA or thereabout that Lagos State Special People Law capitalize on to also make very expansive awards in certain instances, which came up in the case I reviewed. Although I now criticize it that Lagos State cannot make that law because it is not one that is under the residual or concurrent list. So, to my mind, those are some of the 2 things that I think we can also look into as far as regulators are concerned, or regulatory landscape.
Okay.
Good
So
evening,
and then there is always, we continue to have what is the big elephant in the room. The fact that as of today, we don't have a single statute. At a point when, please, anybody who wants to take on that should kindly look at what the UK did last year with a revised law dealing with employment. They have always had. We are still dealing with a 1974 Act what exactly is happening.
Good evening, Leonard.
We have to yes, good evening, my
Sammy has
brother.
been raising his hands for like 30 minutes.
Yes, so
Oh, is it there? No, I didn't know that you had come,
my hand has been up. Yes. Hold on, sir.
Well done. Good evening.
Good evening. Dr. Nzom,
Yes.
good evening. Are you still on the call with us?
Yes, she is. She's just
Okay.
muted. I think she's muted.
Okay. I just need to be sure that she's present at the moment because of what I'm about to say. So,
Yeah.
hello, Nancy?
Yeah, I'm here.
No, Nancy.
I'm here, my brother. I can hear you. Oh, okay.
Dr. Nancy Nzom. I hope she's still on the call. You're muted. If you are speaking, we can't hear you.
Oh, yeah,
Okay.
sorry, I'm still here. Good evening.
Okay. Good evening. Good to have you here. Okay, so I just thought to breeze in and give support to Titi. So, but then you asked the question about the regulatory thing, and I thought to redirect us. So the idea of this webinar really is to launch our annual publication on review of development across the landscape. Okay.
Did I actually?
Okay. So, and you know that I don't know if anyone among the panelists have read any of the previous editions of that publication. We've been publishing it for about 5 years now. I think this should be the 5th edition. So if you look into your WhatsApp, I have sent you the near to final version of what will be going out this year. I think the version I've sent to you is just to put the pictures of the contributors and all of that. So this panel was carefully selected. So Mr. Falabi Kuti SN will, of course, speak on the litigation aspect. In our own review, we've highlighted maybe just 2 or 3 the significant cases because we have other things to talk about, so we're not able to spend as much time on all the cases. So we've highlighted just about 2 or 3 cases. The one on POPA the cases on Public Officers Protection Act, Okoronko and Dr. Regina Eze. The Lacasera case, of course, is there. And I think that Olatunde and is it Access Bank also. So those are the cases in litigation. Now, the reason why we have Mr. Bello is actually brought as an in-house person to talk about, how, maybe even how some of the litigations may affect, but mostly because of the regulatory developments. So if you open that publication, you will see that there's a section. So that publication is usually divided into industrial disputes, employment litigation, then regulatory developments. Then we usually have a look ahead, things that we expect to happen in 2026. That's the way it's always been structured. So for Mr. Bello, for instance, he will need to read, of course, read everything, but pay more attention to legislative and regulatory interventions, starting from page, the pages are not showing here. So, but under that under that regulatory intervention, you will see the general implementation directive relating to data privacy is there. The Nigerian Tax Act is there as it affects employment, payee, and all of that. And that's like the biggest story of 2025. And then you have
National Employment Policy.
Yes, National Employment Policy and National Industrial Relations Policy. I'm still going to send you the final document because I think there were still some little changes. So those are the key things that we
pension reform.
Yes, pension, exactly. Pension reforms under Pension Revolution 2.0. So that's what most of the in-house people really will be coming to hear.
Absolutely.
So the moderator needs to, I don't know how you want to play it. Maybe you are going to draft questions to prompt on these different areas.
Exactly.
But
that will help.
that's what the format is meant to be. Then for Dr. Nzom, we brought you in as an industrial relations person. So the first part of the publication talks about industrial disputes. Of course, the Dangote Refinery and Pengassan dispute is there, and the strike action by ASU and resident doctors, and then pretty much any other overarching discussion you want to have on.
And maybe the amendments of the agreement with ASU now with the new,
yes,
with
yes.
the new terms, and how you see that playing out in 2026. Should we expect more strikes if there are new implementations, stuff like that?
So then the look ahead really probably would everyone can chime in on that. But for look ahead, if you look at the publications, we've highlighted 3 key legislative developments we expect to happen in 2026. The first is the reform of the occupational health and safety laws with the bill awaiting passage by the National Assembly. We also highlighted the NSITF amendment bill that is maybe going to be passed too. Then the informal sector employment regulation bill, the one that seeks to protect domestic workers and all of that. So we really need to, the panelists would need to find time to really read this publication so that they can bring out the relevant part, because different people will come there to hear different things. Some people are more about the regulations and all of that.
How soon are we going to get this?
You'll get it today. I've sent one to you, which is near to final. But the
Did you
final
send
draft.
Did you send
WhatsApp.
it to Elan?
No, your private WhatsApp.
I know. Oh, okay, I've seen it. Okay, fine.
Private WhatsApp DM.
Fantastic. Okay, that's fine.
So that's it. So Titi, so it's just for you to coordinate how you want to play the session. How many minutes you are giving to each person? Is it
how many? What's the duration of the session itself?
Tell me, what's the duration of the session?
2 hours, sir.
2 hours. Okay.
Yes, as taking that was the Q&A session for those who as fans who would have questions also. So the idea is that we have each speaker speak for at least 25 minutes, at least a minimum of 25 minutes. That was their
So, sorry.
question.
Okay.
Yes, Dr. Nzom.
Okay, you were saying something.
Okay, good evening, everyone. Okay,
Yeah.
I wanted to say something, right? So if I'm actually going to come and employment relation view, because if I'm coming into the aspect, one of the things we actually look at is what actually led to these disputes. What prevented as in how can we prevent the dispute? Saying that the dispute did not start when the strike action was issued. I'm sure there've been warnings and all that. So if I'm actually going to come from that aspect, so these are the kind of things I would be talking about. Though I will talk about the strike and all that, but it's going to be mostly, the union didn't just wake up one day and talk about strike action. I'm sure they must have given warning, and this warning was ignored. And also saying that I've probably told them how this thing works, these issues come up, and the employees actually lay these complaints, and the organization ignores them. So definitely the union will have to go and seek help somewhere. And the employees will go and seek help somewhere, and that's where they go to union. And this, if I'm actually going to come in that aspect, because that's what employment relation is all about, to saying, you can actually, this dispute can be avoided. And this dispute can be avoided, even if it's like we can actually find a way to resolve this dispute. Most times, this is the dispute, is just to sit down and communicate. So basically, that's what employee relation, in my own opinion, is actually talking about. Then look at if we talk about the pension, like we talk about the tax now. So these are the kind of things to let them know that employee wants to know why their money is deducted, what amount is deducted, why is it deducted, and they don't want to know if this money is deducted, is it being paid? Then you talk about the pension, they want to, because most of the time you see that employees ask questions and they are being ignored, and it's because of they are being ignored, that's why they run to a union. So these are the kind of, because Mr. Lennox talked about the ECA. So one of the aspects, again, which is actually coming up every day, is more about the NHI, the National Insurance Act, the National Insurance, which was in 2022, which was said that every employer must actually register for health insurance from the employee, which 10% from the employer, 8% from the employee. So that particular act is coming up like every time and that. So that's why I wanted to be very clear. Because if you're coming under, like you're actually responding to the question as an employment lawyer, the view is different. But if you're coming under an employment relations specialist, you're actually talking about the dispute. What led to the dispute? How do we avoid the dispute? How did this dispute start? Where did it get to where it is? How it got to where it is? So I
Yes.
wanted to know if that's what you want me to talk about, because the note I prepared was towards that angle. And 2020, what we look at in 2026, what the organization must do, what they must avoid. These new laws that are here, they should look at it, avoid it, communicate. Most of these laws are something that employees,
Okay. Hello.
so they
Are you
have to
still
do
there?
regular trainings,
Okay.
explain to them more. That's the aspect. Yeah, I'm actually looking at. So I don't know if it's okay,
Okay.
or I need to do
Jay,
more.
Jay,
Thank
Jay,
you.
just a minute, though. Just a minute, so that you can take everything together. You can take both together. I'm sure I missed you when you started explaining. So you need to explain again. How do
Okay.
I come in? You understand?
Okay.
Let me just hear. Yes.
Okay.
So
Okay.
you need to align
So
your
let me.
structure. So explain the
Yes.
structure. This thing is
Okay.
about what? How are we here?
Okay.
Let me hear
Okay.
you and then.
Okay. So let me explain again. But let's say while I'm explaining, if you look into your WhatsApp private message, you see a
I've seen it.
document
I've seen it. I've
Good.
quickly gone through it.
Yeah. So what we're actually doing is a webinar to launch that publication. So we expect that the discussion is centered around that publications, and then a panel to discuss that publication, or at least the developments mentioned in them. So this panel was carefully selected for Leonard Silk to talk about the employment litigation aspect. So while you were on the call, Leonard Silk, I was explaining that because our own publication straddles both litigation, regulatory development, and industrial disputes, we have only focused on very high level few cases in litigation. So if you look at that publication, we've only highlighted the Lacasera case, the cases on POPA, and
Okay. So I should just limit to those cases and I just keep quiet, right?
So you can, and that's why I think this depends a lot on the moderator and how skillfully she can manage the discussion. So even when you mention that, there's nothing wrong in you then mentioning other developments too, maybe related to those ones, like the way you were mentioning other cases on
No, we will limit it. We will limit it. The only thing I wanted to say
Yes,
is that okay, no, it's okay, it's okay. All right, so you can take orders. When you talk about legislative regulatory intervention, of a truth, except we are just dancing around what is not. There are no regulatory interventions in Nigeria now in the employment law space that are recent. And looking into the immediate future, well, I mean, same, of course, for the informal sector bill. And looking into the in the immediate future, I imagine that the informal sector might be, but well, that's not my call. But whoever is dealing with that, I think a webinar like this or the activity should also be geared at seeing what can be done or what is being done to really push
yes,
a
yes,
comprehensive because I mean I'm sorry I've gone through. I don't. That's the truth, and maybe that's why I attempted to just believe that it's just what the court says that is the law in the employment law in Nigeria in not just recent years, almost like 10 years, because even what you would call the law, what you find out is that those who should be implementing in their daily businesses, they don't implement. And that's the reason why you have a law of 2010, ECA, and half of ECA has not been thumbed in the court to challenge or to even understand, whereas it is. So yes, that can be looked into. So for my own space, like you said, I'll limit it to it, but if time permits, could just straddle it again, to use a word, around the possible areas that having a law, a substantive law, can help. Do you understand?
Exactly.
And that's
Exactly.
about it.
Exactly. Because it's actually meant to be a commentary anyway. So,
Yes.
and of course, when it comes to commentary, you can always add that sidebar about how maybe holistic legislation
then,
can address
at the
many of
risk
these things.
of immodesty, but to emphasize it, at a point, this sort of a thing, I should tell you that putting together a review takes me a month.
Yes.
That's a month. And in fact, it's been disciplined that it takes me a month. So you can understand, if I have to get involved in something like this, that there's a tendency to remember. It's usually the whole of last week in November till the end of December. That's when I just going through all the judgment, going through and then reviewing if it's what's been said in the area and all of that. So maybe that's really what makes you want to perhaps take some definite position generally about labor and employment law space in Nigeria. Okay.
Yes, yes.
I'm serious. It's coming up. I don't know what I tell my colleagues in the last 10 years, I don't allow anybody to do it, because I've always been, if I don't read something, if I allow somebody else, I'm not sure I will get the same understanding. And I'm reading half of it, and I'm just, if you guys know what I go through the last week in November to December, to be able to put up what I think is just a sum and a lot of what one discard, that how on earth can this still be happening in this day and age, is getting the attention of the court, and the court is relying on the inadequacies of the law, or is just clearly not understanding the basis of many things and all that. Okay, sorry. Thank you so much. I'm okay. Please, Jay, please go on.
Okay. Thanks, Leonard. So, I already spoke that Mr. Bello would speak to the regulatory aspects. Again, the same comment, which is the publication is taken as read by those who will receive it before the webinar. So you may want to dwell more on high-level commentary, again, prompted by the questions that the moderator will throw to you. It will help if Titi can get those questions ahead. So the question should be more like prompting as to how the cases, the regulatory development, what implication it has for businesses, for individuals, and all of that. So to elicit that kind of commentary is what we expect. And then the same goes to Dr. Nzom. And you are right, Doc, that you are coming to speak as an industrial relations person. So if you are speaking about the Pengassan dispute, the ASU strike, resident doctor strike, it is, you are in on good footing to talk about the root causes and how to avert future ones. So that's welcome. But we still expect that you give your own commentary on the actual disputes that we've highlighted before any other ones that are not in the publication. So I think that's it. In terms of structure. Yes, please.
So I was thinking, and we are allowed to tweak it. I don't know how it works. When we expect to have the highest number doing the discussion. So I don't know if it will be appropriate that we start with the regulatory, as against starting with the judicial decisions, so that we use that to pull people into the room. Then after discussing the regulatory, we go into the judicial decisions, which the Learned Sip will review, and then we go into the issues of the industrial reform and dispute that Nancy would speak to, and then we look at 2026, how we see all of this play out and how implementation will work. The reason why I'm saying so is that at the beginning we might not have a whole lot of persons, and I don't know if it's my bias, maybe because I'm a litigator. I feel most persons will come in midway, and it will be good that we're having the judicial review of these decisions when we have the largest possible numbers, as against having it first at the beginning. But I thought to, of course, ask, because I don't check the numbers to check when we have the highest number of persons in the room, or the specific topic you feel the audience are more inclined to want to listen in on. So I thought to ask that of you.
So my own opinion, and this is my own personal opinion.
Can I
Number
lend my
one,
opinion? Can I lend my voice before your
okay,
opinion comes? You
okay.
know, we won't allow you to speak there. Titi, you are
This is
carried.
something.
You are carried. That's the way. You know, if at the point I tried to join the what's it called? There was this group. So that's the way. When we agree with you, you are carried. Absolutely share your thoughts on that. So Jay, go ahead.
Okay. So my own opinion is, when you're having these kind of sessions, especially where you have a number of speakers, you know, I keep emphasizing that it's going to test your skill as a moderator. I liken this point I'm trying to make now to what we always face when you bring my Lord Justice Kanyip for an event, and you may end up spending all the time on one discussion. So now you have 3 panelists and you have a whole lot of things to discuss. I don't think that you'll be able to manage the time if you allow each speaker to speak on all their, I mean, maybe someone comes and speak on all the regulatory things, and then you want to move to the next person. By the time the first person and second person are done, you may then say, oh, we don't have time again for any other thing. So what I would usually advise in this kind of setup is you alternate the discussion. So you are the moderator, you have all the things to discuss. Ask a question from Mr. Bello, next question to Dr. Nzom, next question to the Leonard Silk, so that at least each person has a bite across the whatever. Because if you say you are waiting till you have a large group, a number, before you go into litigation, the people who are coming, it's not like anyone wants to join will join. Not that they are saying, I'm coming there to listen to litigation, and I don't know. So, but my own concern is, how are you able to ensure that you cover the field within the time that you have, and you still have to allow the audience to ask questions?
Noted.
Okay, Mr. Jami, if I'm going to say something, I'm actually suggesting, if the learner SIG is going to talk about the cases and I have to come and review the same cases, won't it be more of like repetition? Because if we have the learner SIG review the cases, so everyone understand, oh, this is what the case is all about. And then Mr. Bello might actually come and say, oh, what the implication of the implementation of this or the implication of these particular cases in-house, as you said. And probably I come talk about what led to where it is now. Because if I have to review the cases, it's basically going to be saying almost the same thing the learner SIG has said.
Okay, Dr. Nzom, I'm sorry.
Yeah.
I think there was a time we're trying to get your attention. So I explained before, you are not here to review any cases.
Okay.
I forwarded the publication to you on WhatsApp too. If you check your WhatsApp, you see a message from me. That is the near to final draft of the publication we are reviewing. And I had said that you are here to talk about the industrial relations segment of that publication. So your contribution is actually limited to the developments listed under industrial dispute, the Dangote Pengassan dispute, the ASU strike, and the doctor strike. I think those are the 3 major ones we highlighted.
Yeah,
so, but there's nothing that stops you. If the Leonard Silk is talking about a case and you also have an opinion, of course, the moderator won't stop you from venturing an opinion. But she will not direct a question to you.
A question to you, absolutely.
On a case.
Yes.
So if you have a Leonard Silk now, there's nothing he can't talk about amongst all these things. He has already talked about pension and all of that. So if Mr. Bailey is talking about the pension 2.0 reforms, he can say, oh, I remember there's a case on this. That's his own commentary. But his own primary responsibility is the litigation.
Yes, okay.
So that's what it is.
What's the time span again? Sorry, for the
2 hours,
for the entire. Okay, that's fair. That's fair.
Yes.
That's fair. I mean, if it so we keep to time.
Mm.
I have another one in the morning, and I don't know how I agree to that, and I reckon it's going to span till 2. That's from 11 till 2. So this starts 4, right?
Yes, 4.
Okay. Okay.
So Titi, you can just mix the questions, and if you draw up a list of possible questions that you're going to ask, you can circulate it before Friday.
Yes. So it helps us to just, in fact, I would expect that it helps us to. Titi, I think that is the best, though. You know, one thing with me, and I always say it anytime I'm invited to speak in anything, and then it's going to be a question and answer session. I say that, please, can I have an idea of the questions? And I think I learned it watching some of my mentors that you bring them, they'll just go on. So, and I can also go on, but if I had an idea of the question, I'll tell you that I'll be mindful of the time. I'll just hit the bullet and then leave it open there. So it's good. That's for me. It is. But if you ask me, I don't have a pre-knowledge of it. What I'm not supposed to say, I would have said it before.
Exactly. And because I know that with this kind of discussions, there is nothing.
In fact, I will turn it to a discussion. I would have forgotten that this is a time-tenured session. You understand? I'll turn it to a discussion. So it helps. So it's not like.
Yeah, because if you are not careful, each of those developments is a webinar on its own. Let's say you remember that you went on Easy Channels and you spoke just on the Dangote issue alone. I'm sure, so I'm sure that probably took 1 or 2 hours. You know, people can seize on the Dangote issue and you spend the 2 hours on it. Same thing with La Casera case. There's nothing in that place that you cannot spend the entire 2 hours. So which is why I said you have to manage the time very well and make sure that
and no matter what, Benga and I, we already have a slot to discuss La Casera. So Titi, be mindful. We already, so in between that, maybe you create 10 minutes for us. We won't consciously, something will come up and then we'll say, because we already take.
My intervention on La Casera will not take long. It's going to be snippets. I'm just going to look at this, and I promise I won't do more than five minutes on La Casera.
Okay.
I won't do more than 5 minutes. But I mean,
by the way, Benga and Jamil, how come this your overland? You know, I go to industrial court a lot, and the other day, before what's her name, Hoji, I noticed that we had an overland case. Somebody from your former firm. Then just yesterday, I was before what's his name, Yawa, and there was also another, like I said, overland.
They always find They always find
in fact, I'm sure they must have become notorious now. And personally, I think the court will start to form an opinion, an adverse opinion that might affect the way the court looks at their employment policies and their general attitude to them. It's not good for them. One of the things I tried to discuss with the MD, chairman at the time, was that, look, you need to really minimize and start to re-engage some of the. But I think he's an Ogbologbo as well. And you know, when an Ogbologbo meets another one,
so, but I feel differently. I feel differently in the sense that I think the choice that the airline may have to take to avoid this kind of issues, they basically just stop training pilots.
Which is dangerous.
Which is
exactly.
So
exactly. I agree with that, Jamil.
Because what Dana does, remember those Dana cases? All those Dana cases and all the other ones, they will not train the
they will just put pilots. You on the plane.
So once the pilots get the qualification, they just snap them up
and put them on the plane.
And that's why Overland always keeps saying, no, we will stop, we'll recover. So if they too now adopt the process, we just look for pilots who have already been type rated, who already have their licenses. They won't have that problem again. But then, who will now train those pilots? They are always not willing to. They are always.
So it's better to just take it up on principle. In that case, I salute them then. I salute Overland for
because those things are very expensive. Their trains are always very expensive. They're always in thousands of dollars. And for some reason, these pilots, once they land, They start going for
You
the next
know,
highest bidder.
please, you people just indulge me. All these things will always bring a few things about. So some years back, Bridge Clinic used to do the same thing for medical doctors. So what happened is that apparently when medical doctors go through universities and all of that, I do get maybe medicine was not advanced, or it's not advanced. So I wouldn't know about now teaching them about artificial insemination and what they need to do and all of that. So at the point when Bridge Clinic started in Nigeria, engage doctors and retrain them, retrain medical doctors on all this artificial insemination and all of that, and entered into a bond with them that you won't leave until maybe 4 years. And if you are to leave, you flout it. A guarantor was also provided. The guarantor will pay 2 million. This was about 7-10 years ago. Yeah, 7-10 years ago. So in no time, 2 medical doctors left. Bridge took them to court, and they lost in the 2 cases because the court said it was onerous. It was 4 years or 5 years, and the fact that guarantors were also meant to pay and all of that. So I think the gentleman was unhappy about it, who owned the hospital and all that. And the HR personnel contacted me to look into possibility of taking them on an appeal. And I just look at and advise that, okay, you can look at this, do this and all of that. Guess what? Over the years, they don't have cases like that anymore. What I've not found out is that when I stopped training, we found a way around. But medical doctors will go there and they were leaving. You understand? And I just said, no, you were breaching your bond and all that.
Of course.
But he must also have done something like that, because then they had a dealer job. Apart from those 2, 1 or 2 or 3 other ones went on and all that. But there's a whole lot of
they will simply not train people again. The ones that don't have cases, let me tell you, Leonard, this is the truth.
Yeah.
Because sometimes being practical on the field, those who don't go to court is because they have a hold on their employees. They actually hold their certificates in their custody.
Now I wrote about that years ago.
Yeah,
Jay, in 20, if you go and see my review for 2008, for some reason, I came across 7 cases where certificates of pharmacists. So it was something that was in that sector. Pharmacists, after training, and they are being employed by Pfizer and all of that. We're not Pfizer. The indigenous pharmaceutical companies that were coming up.
Okay.
Part of the employment policy, you deposit your original certificate. So when they were leaving, for some reason, about 7 cases were decided that year. They had to do with an ex-employee filing to retrieve original certificate, because the employer agreed now decided to punish that. Okay, I won't release your certificate, and maybe they agreed within that sector that I don't want to employ anyone without collecting original certificate. I was miffed that how can that be? But as would have happened, Industrial Court made 7 decisions that year.
Yes.
Benin, Lagos, Ibadan, they had to do with instances of similar practices that the court now to say it was an unfair labor practice.
You know that.
So it was something that was common in the pharmaceutical industry.
It's common. And the honest truth is, yes, unfair labor practice. But employees are wicked too, in a sense. Do you know that the federal government, as an employer, is one of the greatest victims of this issue? Remember, right from all those Awojodu cases till now, I was reading just this week or last week that the federal government has now decided that it will stop training peoples abroad, that they are not giving foreign scholarship again to their staff, because people just go there and almost by default, or everybody that goes there, the federal government spends a lot of money, forex, training you, accommodation, blah, 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 and you just go there and you japa and you don't come back. And they are not getting the benefit. So private employers, the only recourse they have is to hold on to something that they know you will have to come back.
And this thing you just said, Jamiu, you remember that when we filed the first 2 cases in Overland, we lost woefully. And And I remember that this man called us, the MD, and said, look, that it is important to now to present our case as a story on how training enhances the industry, the value, and the industry as a whole. That the lack of training is some of the reasons why we are seeing incidents occur from time to time. Now, this thing you said is very important, Jamiu. What I also think now is that the lawyers who are presenting these cases must be very ingenious in how they put it, so that they can make reference to former cases in a manner that suggests that, look, there is now pilots are beginning to take advantage of the generosity or professionalism of the company to come there to train, then zap to another place who will not train them but pay them so much, and it puts the whole industry in jeopardy. So it's all deep. But unless they make that explanation, most judges may just start saying that overland again. What's happening?
Yeah, I agree.
Yeah.
Joby, you know what I'll just quickly offer? Don't travel too far. Any lawyer going to that court should, and in advising our client, be conversant with the FCCPC Act. I can assure you, when I did the review and I pointed out section 68 sub 1 of it, after that, I'd seen one judgment that referred to it. So the point is this: legislation has now specifically said that what might have been a practice festered under common law, wherein the employee can enter into a contract that train me, avail me this, and in return, I will charge you for anything beyond 2 years, is no longer available.
Do you, in your own view,
hold on, statutory legislation will displace.
How can that legislation?
Go and read section 68 of FCCPC Act. The asset contract of employment, you cannot do two beyond 2 years.
Says, but practically, let me tell you something. If you hear that a company trains anybody, what they are training you for is not commonplace. Nobody trains anybody to become.
You limit your exposure. That's what I'm saying. They should limit their exposure.
If I train somebody, and listen, these trainings usually are outside of Nigeria. I've spent some good fortune. And when you come back, you're not going to become an expert immediately. I'm going to still have you for 1 year struggling. Maybe the second year, if you are really brave, you become an expert. Are you telling me that 1 year is enough for me to gather what I have? I mean, come on. I think that legislation was not thought out. I personally, I don't think it affects any contract.
That legislation copied the UK model.
I don't look.
FCCPC. Yes.
I will argue that FCCPC does
no
not
problem.
affect any contract. I will argue anywhere.
No problem. But I can tell you that what's in that circumstance, I would advise my client is, if I'm going to train ordinarily to be a pilot or to have this specialized training, I need to send you abroad for. And this is the vast exposure. And in return, I think the consideration can be fully met. If you stay with me for 3 years, I'll find a way to limit our exposure to 2 years and perhaps ask you to part fund or take it off your salary. There's a way. It's just to redesign. Let me tell you, what is important is, avoid what could possibly lead to the green prospect of the court saying that you're unfair, because it's legislation. It's legislation. And they say legislation override. Don't forget the thinking. The thinking has always been. You know what the court will tell you? Supreme Court has said, once there is a contract, hold on. Once there's a contract between parties, the Supreme Court has now agreed with the industrial court on it. And the contract was made by the employer. And it is possible to give rise to multiple interpretations. On the one hand, this is what we agree. On the other hand, this is what the law says. The multiple interpretation is that
there is no multiple interpretation.
The multiple interpretation is that you will be saying,
there is no
hold on now.
All you have said
is that interpretation that you will be saying that this man is
multiple interpretation.
What bargaining power?
is not what
Industrial
people with
court.
interpretation.
No, have you forgotten that the whole essence of labor dispute or adjudication this day is not necessarily about privity of contract? Do you agree?
No, I don't.
Privity of contract is now being displaced gradually, and that is why you can bring a third party into a contract.
And you
So
see, Falabi, that they do these things. Falabi, get one thing. That
No,
they
get
do
get
these
one.
things. I
Joby,
see it. I see
Joby,
that they do
if
it.
I am
But
to
I see
criticize,
that they do it. That they do it in
doesn't mean it's
itself.
right.
Does
Doesn't
not
mean it's right.
mean exactly.
Can I tell you something?
I
Joby,
see
you
the
know me
thinking.
now. You know me. My research is always on comparative analysis. I
So,
can tell
Falabi,
you
I'm coming
everything.
from a
Hold
practical.
on.
See,
I
if I
can
give you
tell you
another
everything
example,
about triangular employment, where they imported it, came from 5 advanced jurisdictions. Go
yes,
there. That's what you'll find.
yes.
Even long before we ever mentioned it in industrial court. So what are you saying? What are you
Falabi,
saying?
you see, honestly, you
We
are
took it from other places
Falabi,
as well.
I don't begrudge your thoughts and
Yes.
how you communicate. I don't begrudge the legalese at all.
Yes.
From a lawyer's perspective, honestly, you are right 100%.
And you
What
know the
I am
other thing I'm
saying,
waiting for you. You know the other thing I'm
as
waiting
a
for you.
wait,
You know
as
when
an
you said,
wait,
Joby, let me finish now. You said when you said the other day that 5 years, I threw it back. If you are coming to speak about Lakasera, please don't say anything unless you have an authority anywhere in the world. And I repeat it here, anywhere in the world where
Falabi, I think you see another thing.
where restrictive
Again.
covenant has been extended to 5 years, not just Nigeria, anywhere in the world.
Falabi, it's a question. Again, Falabi, wait. Again, it's a
Anywhere
question
in the
of mindset.
world.
Falabi, again, is a question of mindset. And I see that, like the National Industrial Court, it is easy for people to pick a number and say, no, this number, you attract it or you attach it to a particular case and make it a rule of thumb. That is the problem I have. I have said 5 years and you said, oh, there's no authority. I am considering now that there's no authority. Falabi, if today a restrictive covenant is enforced all over Nigeria, it will be struck down. Andreas Kumulis enforced that thing across all West Africa. So we keep looking at the number of years. There are other variables. And these variables are determined. Wait. These variables are determined by factors of production, factors of competition, protection of information, and the person's innovation in bringing that thing. It's a lot of it. Sitting here, Falabi, what you guys call triangular employment, it's a safety net for employers. And it is not to avoid liability. And one of the things people think, and honestly, it takes somebody to sit down in a company and look at, oh, this is why this thing is being done, not necessarily to avoid liability. People think that, look, IHS has 17,000 sites.
Finish one. Just finish one. I don't want to lose that trail.
Yes, you have 17,000
I don't want to lose that trail of thoughts. Finish it before you go to IHS. Yes, go on.
Okay, maybe you should. Okay, maybe you can go on. But
okay, I'll just throw something back. Andrew Kumulis that you mentioned, Udo Doma 1972. Udo Doma relied on a 48 decision of the English House of Lords. That was 1 year. Andrew Kumulis was 1 year. Do you know what we're taught in law? What we're taught, on my understanding of the law, is you must relate fact to the peculiar circumstance that we're complaining of. The only thing I put down anytime you mention restrictive covenant, and I would defend because I have done the research, almost to the point where I can tell you that I know what I'm talking about. You can't find anything contrary. GOB, we used to argue in inside conference room, Preston and Grace. You know now, law, Friday, we'll be having litigation meeting. We'll take him on. We'll run into the library, we'll bring in the books. This is exactly what I've done with this area, in this area. Let me tell you, Kumulis was 1 year. The English authority relied on was 1 year. Why are you citing Kumulis to
so again,
affirm?
You are
Hold on.
on the
How are you citing Kumulis to affirm 5 years?
Falabi, don't let us board these people.
Simple.
Don't let us board these people, please.
The court have said that.
If
No,
you
the
keep
court have
hanging
said that you
on
must draw
it,
the
for me,
balance. You
it's
cannot
not
hold
the number
anybody now
of
for 5
years.
years. It's not
You see,
any way.
again, you are hanging. You keep
That
talking
is what
about
hits at the heart of restrictive covenant.
no,
That's the very thing that hits at it.
no.
This is
that
how
is
long I
not
can
it.
enslave you.
No, that is not. I'm sorry.
GOB,
Yes,
let me ask a hypothetical question. No.
This
yes,
is a major thing.
If you hire me as an engineer or whoever,
yes,
and you decide on your own, I
yes.
want you to have, okay, let's even say I'm a lawyer, even though they say you can't bond lawyers. I am a lawyer. I came in, I say I'm an employment lawyer, I'm doing my work. You say, they said AI is the new thing. You must become
Yes.
an AI expert in this firm. And you send me abroad. You spend $250,000 and I'm doing the work. Does it make any difference to your position that me, I want to pursue other opportunities? So, and I said, no, because I trained you in AI, you can't go. Will that play? Because unlike the pilots, for instance, what these airlines send the pilots to do is a type rating.
Yes.
Without that rating, they can't even enter that
Fly the
aircraft.
plane. Yes.
And it is beneficial to whoever they go. Anywhere anyone has 737
Absolutely.
and you have that type rating, you'll be able to fly. But if based on your own business needs, you just decide I want to train this person in this whatever, and I, as an employer, I say, okay, I'm no longer interested in working for this place and I want to go. Why should I even return your money in the first place, even what I'm going to? Because you know that in the US now,
So Jamil,
in the US, do you know that in the US they have even banned non-compete?
There's an error in this thing you just stated. There's an
In
error in
US,
this
they
thing.
have even banned it in I don't know whether it's in one of the states. The FTC banned non-compete totally. They said it's disturbing innovation.
Jamil. You see, all those things, everything you've just said now is a roll-up between bonding and what's it called? And receiving called. They don't achieve the same thing. Or let me put it this way. They both
No, they
flow
achieve the same
in
thing, though.
No.
They
They
are all,
flow
no,
in parallel. They
Joby,
are
can I say this?
parallel.
They are all species. They are all species of restraint of. Hold on.
It doesn't.
You
No,
know,
a
see,
bond does
no,
not. Number
Joby,
one, Falabi, understand.
go to see this. I learned
Like
from
Jamil said
contract
now.
part
Like
2.
Jamil said, wait.
Go to Sage contract part 2. Restraint of trade covers it's used to cover quite a lot, and the whole idea is that no man should restrict the order. That any such contract is a legal contract unless we can show reasonability. Sage explain it. Contract law. They did not give examples. Non-compete and all of that. They are restraints. They all come under that banner, restrictive covenant, because you are trying to bar a man from putting his skill to use to earn bread for a period of time. And what the law considers to be reasonable, I'm coming, is that length of time. The law doesn't say it's wrong, but the law starts on the premise there's a negative contract. We don't want to hear it unless you can show me there's reasonable. And how do you show me it's reasonable? You show the length of time as to what you've invested. It's as simple as that. Every other thing is to go and check it. That's the philosophy. You want to show that it's reasonable because you need to demonstrate that I will stop you from doing this for a period. All I say about this in all my articles, go and read it. It's period. I don't talk about any other thing because the law says it's right.
Falabi, it is easy for us to speak all this grammar until the day you become a company executive. Let me wait.
Joby, can I tell you something? I went to IBO. I sponsored a senior. Do you guess what? I went to IBO, Canada. I sponsored a senior in my office. I'm just 2 years as a framework. So what are you saying? Wait now. We both went to Canada. The guy could come back and leave now.
No, that one you can't bond him for that one.
You're not even giving the grace of making.
But you did not like that. You know how much I spent?
It will be painful,
Falabi, you continue to talk about this from the textbook perspective. Falabi, I want to give you a practical experience again in a case I have done with Jamil.
Yes.
And I'm going to mention names. There is a Hygeia. Hygeia used to be the biggest HMO in Nigeria. Used to.
Yeah.
IGEA had a woman who sat on her board.
Yeah.
She's the custodian of all their strategies and customers.
Yes.
And strategies they use and blah, blah, blah. She's a lawyer by training. But because she had been in that system for some donkey years, she has acquired specific knowledge. Now, listen to this. Listen to this. By her contract. Wait now, wait.
Is that people Ukiri's case? Go on.
Unfortunately, you guys are so fascinated by the legalese of. You're not listening.
Is that Ukiri's case? Don't answer first. The one you are going into now.
See,
is that the one involving?
You mentioned it like a lawyer. Ukiri. If I'm talking about it to some people to shine, I'll just say Ukiri, and you see, you're not listening to the background.
Okay, now, go on.
This woman became an authority. Let me put it that way, because she became the strategic partner to dealing with customers. In her contract, she has a 1-year garden leave that entitles her to sit at home, collect salaries, and blah, blah, blah. The day she wanted to leave the company, she started whipping up sentiments. The truth is, we all know that it was Olumelu who came for her. And she insisted on going to that place. In fact, she resigned and went to the place. My question is this. She's a very, very cantankerous idiot. Now, let me tell you something. Folabi,
yes.
Imagine you sit as the chairman of IGEA. Do you know that in the first 3 months, this woman went to, what's it called? To Hears. The first thing she did was to call her customers and said that I have moved. Now, unfortunately, unfortunately, at the time we were doing these cases, we did not have that evidence in full proof in a manner that you will submit it for admissibility. But they know that she had tapped those people. They know that she had tapped those people. And those people had already started dropping. Let me tell you what happens. People don't write to HMOs to say, we are not using you again. There is a systematic way. All you will see is that there is a decrease in visitation by staff of particular companies to certain hospitals. That is what you will see. Now, Folabi, these things are operational in their effect. It takes a while before you now start seeing it in Naira and Kobo. Today, Hears is the biggest HMO in Nigeria because of Ukiri, because of an unfair situation. The court did not even consider the garden leave at all. Wait, Folabi, wait. Chill.
No, I'm listening.
Now, this covenant was for 2 years, or 3 years, with the garden leave. So effectively, it is for 2 years. My question is, Folabi, what has happened has caused an economic disruption that is unfair to IGEA. Is anybody assuaging that to IGEA? Economically, is that imbalance being corrected by this decision that we are making? You see, let us remove this. The law says, let us sit in an office and tell them to give you numbers, Folabi, operationally and financially, and see the loss that happens to these companies as a result of decisions that are not well reasoned. Not well reasoned, not because of the law, but because people don't even understand the operational effect and financial effect on corporates. But all we do is, this is what the company says. This is what...
Joby, I'm not blaming you guys. Can I say this? You see, I listen to you. I won't blame the approach that was taken to deal with our case. Of course, I recognize the competing need to balance. They need to balance the competing interests, which will never meet anyway, of the employer, of the employee, and the fact that it's not just disruption. It can cause colossal economic loss that cannot even be put in naira and figure. Because you know what? The prospect of the fact that she did this, we could get this, you can't estimate it. It's like seeking the injunction and say, you know what? We can't even estimate how much is going to come. But can I also say this? And I want you to go check it. I'm not blaming you guys, but I can tell you that there are instances where that has been dealt with and she would have been gagged forever. Do you know that the way
who
they
will guard,
I'm coming?
who will
No,
guard
no,
her?
no, so it will
Who
depend
will
on how the
guard
case
her?
is taken. No, wait
Who will
now.
guard her?
Wait, see, taking barrier. What you are saying has happened. I have just forgotten. Ted Turner, CNN, there was some particular show, late night show host, whether it was Johnny Cass, I can't remember. But this happened, and it was the memoirs I was reading. Guess what? They went to court. They got a restraining order. They didn't have facts that you've disclosed confidential information. Do you know we randomly put confidential information? You have a duty not to breach it and all of that. But I continue to tell people, not many lawyers understand how this thing works. It's not industrial court matter. It's not industrial court matter. It's in a contract of employment. It's high court.
Falabi, in Nigeria,
I can understand it. I'm coming. I can understand the limitation of our system. I'm coming now.
First things
I'm coming.
first, if they tell Sumbo at that time, let's assume we file something called interrogatories, and we
I
say
got
that
to throw out that case, so let's see.
when we
Limitation. They will tell you
at that time, Falabi, wait. At that time,
text of confidential information.
Submit
Do you know the way the English
examination.
lawyers treat it? They'll just say that they believe that this man has left, and the court is like, oh, we don't have to have facts that is already disclosing or is trying to win over to a competitor, our customers or our clients. They'll just disclose that this is, and then we will file this to say that if ultimately she can lay bare that never happened and all of we will compensate it. It is not the compensation. It is just to find a way to gag. That's the first thing. I'm coming. When you say the High Court will throw it out, I don't think so. It depends on how it's approached. Because the High Court Lagos, the High Court Lagos, from my reading of thoughts in this country, we've not gone to courts to really test the ambit of thoughts law. We've only gone regularly. If you go read the authorities, those regular things around thoughts law, this is thoughts. You start with that, you file a separate case. So think about the case you overwhelm where you try to overwhelm her with the case and all of that. From day one, the English lawyers, even before, the moment she's thrown in her letter, they said the following day they'll serve her something and all of that. You also shake her. She'll be very careful. That's the starting point. And I hear you, and I also, and Juby, thank you so much. I also I'm not a lawyer for employees. I'm a lawyer for both. So I find a way to do the balance. It is definitely not possible to say you can estimate how far when an employee leaves and is a top cadre employee like that. This is what goes with our exit. It is not possible, and I recognize that. But what I'm saying is that there are other ways that you can also move to deal with. But beyond all of that, why are we isolating this particular issue? Have you forgotten that in the employment relationship, the bulk of the benefit rests with the employer? All the factual scenarios you can think of, the bulk of the benefit rests with the employer.
This is one of my problems. One of my problems with the way people just slant these arguments is when there's a cul-de-sac, it's the employers that I enjoy. It's the employers that are.
No, that is nonsense now, Joby.
That's where we're going to now.
Analyze it now, Joby.
Look,
Joby, now see, Joby,
I am sorry. A company exists for only one reason: to make profit. The only thing is, don't make profit at the expense of violating principles. And what we should be asking is that in sometimes trying to bridge some of these gaps with employee, has that company violated principles? That is what, once we now start to do, this is the company that is, come on. The company must survive just as the employee must survive. What are we saying? For me, it's neither here nor there, and we can continue these arguments till Jesus comes, But I really don't want us to stretch this beyond.
We'll continue. We won't have all the time. I'm sorry to have taken you off this and all of that. TTJ, GOB, when he left litigation to go in-house, I told him that he had no business going to that side of the table.
When
So
it
yeah,
is paying my
except to go get
my
money.
bills. When it is
I
paying
know
my
now.
bills.
So let me give you guys an example of how. No, Joby, we must find a way to apologize because this was not what we came out for. So
Please,
listen,
guys,
in
I'm so
Passion and
sorry.
Grace, we will come. So we
Apology
used to
is
have
not
a.
accepted, though.
Okay,
What is
thank
going
you
to
now. So
happen
let
is
me give
that
you the background. We used to have a Friday
let's
meeting
wait
in
before
the
you give me
office.
background. If you people go off script tomorrow, we will
We will
find
not.
you.
We will not. We will not. We will not. We will not. No, we have a way of getting around. So we used to come. We used to have a litigation meeting. So we used to have what was meant to be the end of the week meeting. Joby, that was it. Now it wasn't a litigation meeting. So they will start with reeling out litigation cases over the week in the course of the week. Litigation cases in the course of the week. So say, oh, X and X came up. The court said this has been adjourned to this. So came up. The said this has been adjourned to this. So it was meant to just have maybe 15, 20 minutes. Joby, right? So we used to have 4 o'clock. Guess what? We would then, after that, go to the transactions solicitor department to report. And of course, they'll have to very quickly. We're all very eager to go home on Friday, where they always bring it. Then 1 or 2 things will come up while they're reporting litigation case. Also, I can say, no, but why did you just say this and all of that? Then from nowhere, he will raise this. How we join or how we join. Somehow, 4 o'clock, we'll be arguing cases till about 6. Then the library was so close to the conference room. So in between that, we're having a meeting. We have forgotten to have a meeting. We just dash to the library. No, this is what our authority, go and bring it and all of that. So guess what? After some time, GOB, I don't know if you remember, people like Ifeko, may God rest her soul. She's late now. Anytime we're going into the Friday meeting, Ifeko would just say, Falabi, Benga, I've spoken to anymore. Please, you people don't argue today. Remember, Joe, let them just mention, people, let's go home. Let's go, my people. No, sorry, everyone. Apologies for the backstory. I can assure you we won't do that.
Oh, yeah. Take us home. Take us
We
home.
believe you. I worked in a core litigation firm, and when we are in meetings with Mr. Onigo, our conference room is also close to the library. We'll go and bring the authorities and the statutes, and at times we are there till 10. Having fun.
No, these solicitors, they'll be easy. If I call, they'll be easy. You see, their face will be so drawn. We will be so consumed in the argument. We won't even look at their side. When it's time to go, they will almost want to slap us. Because we just walk away. So next Friday, in fact, I remember Ifeko, the meeting was 4. Ifeko was strolling in my office at about 12 noon. Falabi, please now, please. We know you people, we know the other, please. Please, at 4. I've told my husband, 6 o'clock, let's pick me and all of that. Please, you people. Because they knew that unless that thing finishes, nobody must leave. And they went, that was the time. It's okay. Thanks so much.
Okay. So I've sent questions of us.
Yes.
Please look at the questions. I'm happy for you to tweet the way you like. What I intend to do is the proposal by Jamiu, where I would move from one topic to the next without having you answer all of the topics, all of your own questions, so that everybody would have the opportunity to speak before maybe time runs out. Hopefully, time shouldn't run out. Please, during the course of the presentation itself, if it's possible, I'll be sending you chats to say, please now, I'm trying to tell you, I'll be behaving like those solicitors in your former office to say, please round up now. I'm trying to prompt you, so that we can maximize the time and ensure that everybody is carried along. So thank you so much for your time tonight.
Thank you. Thank you. Thank you.
Thank you.
Excellent evening.
Thank you. I'm sorry, Nancy, for taking your time.
Yeah,
thank you so
really,
much.
I feel for Nancy more than any other person.
Because funny enough, I'm actually in the hospital. My mom had a
sorry.
so that's what
Sorry.
Sorry.
Please.
So sorry.
Sorry,
Thank
please.
you.
Godspeed. Great health.
Thank you so
sorry.
much.
Apologies. So sorry.
Thank
Forgive
you so
us.
much. Thank you so much. No problem. It's fine, sir. Thank you, sir.
Thank you. All righty. Take care, people.
Okay.
Well done.
Okay,
Get
bye.
well soon, eh? Well done.
Thank you, sir.
Yes,
Thank you very much, Sir Thomas.
Okay,
Good
bye.
night.